Hello friends, welcome to ProLaw Shiksha, where we make the world of law simple and easy to understand. In today's video, we bring you 20 important law MCQs that will be super helpful for your competitive exams, judiciary preparation, or law entrance tests. Whether you are a law student or just someone interested in legal topics, this video is for you. Along with each question, we'll not only provide you the correct answer but also for few questions we'll also provide detailed explanation to help you understand the concepts clearly. So what are you waiting for? Watch this video till the end, and if you find it useful, don't forget to like, share and subscribe to the channel. Let's get started. So our first question is: A without Z's consent and with intent to cause injury, fear or annoyance to Z incites a dog to spring upon Z. What offense has been committed by A? Is it assault, B mischief, C negligent conduct with respect to animal, or is it D use of criminal force? And the answer is D, use of criminal force. For this you can refer to section 350 subclause H of IPC. Our next question is: A and B, who are cadets in the Indian Air Force, take out from the Jodhpur aerodrome an aircraft without the authority of the commandant and fly it away to Pakistan. What offense has been committed by them? A. Theft, B. Criminal breach of trust, C. Criminal misappropriation, D. Sedition. And the correct answer is A. Theft. For this, you can refer to K.N. Mehra case. Our next question is: A. By putting Z in fear of grievous hurt, dishonestly induces Z to sign or affix his seal to a blank paper and deliver it to A. Z signs and delivers the paper to A. A is guilty of A. If forgery, B. robbery, C. extortion, or D. cheating. And the answer is C. extortion. For this, you can refer to section 383 of Indian Penal Code. Our next question is: X finds a government promissory note belonging to C bearing a blank endorsement. X, knowing that the note belongs to C, pledged it with the banker as a security for loan, intending to restore it to C within a week. X, A, is not guilty of any offense, B, is guilty of criminal breach of trust, C, is guilty of cheating, D, is guilty of criminal misappropriation. And the correct answer is D, he is guilty of criminal misappropriation according to section 403 explanation 1 of Indian Penal Code. Our next question is: A, in good faith, says of a book published by Z. Z's book is indecent. Z must be a man of impure mind. Is this defamation punishable under section 500 of IPC? Your options are yes, because the opinion respects Z's character. B, no, because it falls within one of the exceptions of section 499. C, no, because it is a slander. D, no, because it has not been repeated. And the correct answer is B, no, because it falls within one of the exceptions of section 499, and that exception is the sixth exception of IPC. Our next question is, A finds the key of Y's house door which Y had lost and commits house trespass by entering Y's house having opened the door with the key. What offense has A committed? A. Locking house trespass. B. Criminal misappropriation. C. Attempt to commit theft. D. Housebreaking. And the right answer is D. Housebreaking. For this, you can refer to section 445 of IPC. Next question is, warrant case means a case A. in which a police officer arrests without warrant. B. in which the court in the first instance shall issue a warrant of arrest against the accused. C. relating to an offence punishable with imprisonment for a term not exceeding 2 years. C. relation to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. And the correct answer is D. relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. For this, you can see section 2 subclause X of Criminal Procedure Code. Next question is, a chief judicial magistrate may pass a sentence of A. imprisonment for a term not exceeding 3 years or of fine not exceeding 5,000 rupees or of both. B. imprisonment for a term not exceeding 3 years or a fine not exceeding 10,000 rupees or of both. C. imprisonment for a term not exceeding 7 years or a fine not exceeding to any amount or both. D. imprisonment for a term not exceeding 7 years or a fine not exceeding 1 lakh rupees or both. And the correct answer is C. imprisonment for a term not exceeding 7 years or a fine not exceeding to any amount or both. For this, you can refer to section 29 subclause 1 of Criminal Procedure Code. Our next question is, no wife shall be entitled to receive maintenance from her husband under section 125 of Criminal Procedure Code if she has obtained divorce from her husband and has not remarried. B. She is unable to maintain herself. C. She refused to live with her husband on the ground that he keeps a mistress. D. She is living in an adultery. And the correct answer is D. She is living in an adultery. Our next question is, a district magistrate or a subdivisional magistrate may prevent environmental pollution under this provision of Criminal Procedure Code, Section 151, Section 133, C. Section 107, or is it D. Section 145? And the answer is B. Section 133. Our next question is, under subsection 1 of Section 146 of Criminal Procedure Code, the magistrate may attach the subject of dispute if A. it is movable, B. he decides that one of the parties was in possession of the said subject, C. he is unable to satisfy himself as to which of them was in possession of the subject of dispute, D. in relation to that a receiver is appointed by any civil court. And the correct answer is C. He is unable to satisfy himself as to which of them was in possession of the subject of dispute. Our next question is, in relation to first information report, which of the following statement is not correct? A. It is not a substantive evidence. B. It merely marks the beginning of the investigation. C. It cannot be used as a previous statement for any purpose. D. The information need not be an eyewitness. The correct answer is C. It cannot be used as a previous statement for any purpose. 54 of Criminal Procedure Code. Our next question is, if it appears to the magistrate that the offence complained of is triable exclusively by the Court of Session, he, under Section 202 of Criminal Procedure Code, postponing the issue of process against the accused, A. shall commit the case to the Court of Session, B. may direct an investigation to be made by a police officer, C. shall call upon the complainant to produce all his witnesses and examine them on oath, D. shall return the complaint for presentation to produce before the Court of Session. And the correct answer is C. shall call upon the complainant to produce all his witnesses and examine them on oath. Our next question is, the maximum term of imprisonment awardable in a summary trial is A. 3 months, B. 6 months, C. 1 year, D. 2 years. And the answer is A. 3 months. For this, you can refer to Section 262, Subclause 2 of Criminal Procedure Code. The next question. The appeal against an order of acquittal passed by the Court of Judicial Magistrate First Class shall lie to A. the Court of Chief Justice, A. the Court of Chief Judicial Magistrate, B. the Court of Session, C. the High Court, or is it D. the Supreme Court? And the correct answer is B. the Court of Session. For this, you can refer to Section 378 of Criminal Procedure Code. Our next question is, on an application made by a person apprehending arrest on an accusation of having committed a non-bailable offence, the High Court on the Court of Session may, under Section 438 of Criminal Procedure Code, give the direction that he shall not be arrested till further order, B. he shall be released on bail without taking him into custody, C. in the event of such arrest, he shall be released on bail, and D. in the event of such arrest, he shall be released on bail 3 days after the arrest. The correct answer is C. in the event of such arrest, he shall be released on bail. Our next question is, if the offence is punishable with fine only, the period of limitation for taking cognizance of it shall be A. 3 months, B. 6 months, C. 1 year, D. 3 years. And the correct answer is B. 6 months only. For this, you can refer to Section 468 of Criminal Procedure Code. Our next question is, inherent powers under Section 482 of Criminal Procedure Code can be exercised by A. any criminal court, B. the Supreme Court only, C. the Court of Session and the High Court, D. the High Court only. And the answer is D. the High Court. Our next question is, A is accused of an act which may amount to theft or receiving stolen property of criminal breach of trust or cheating. He is only charged with theft, but it appears that he committed the offence of criminal breach of trust. He may be A. acquitted, B. convicted of theft, C. convicted of criminal breach of trust, D. discharged. And the correct answer is C. convicted of criminal breach of trust. Our next question is, in relation to the expressions defined in Section 3 of Indian Evidence Act, Which of the following statement is not correct? A. Fact includes not only physical facts but also psychological facts. B. Court includes arbitrators. C. An inscription on a stone is a document. D. A fact is said to be not proved when it is neither proved nor disapproved. And the correct answer is courts includes arbitrators. Because according to section 3 of Indian Evidence Act, a court doesn't include an arbitrator though he is legally authorized to take evidence, but court doesn't include an arbitrator. Thank you for watching.